will be compulsory.
The Bluetooth device is ready to pair.
Hello. 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 Hello.
नमस्कार सभी लोगों का एक बार फिर आप सभी लोगों का स्वागत है इस कार्यक्रम में। और ये हमारी जो है सिविल सीरीज है, रेगुलर सेकेंड अपील इन दिल्ली हाई कोर्ट। हमारे जो स्पीकर्स रिस्पेक्टेड एंड एक्स प्रेसिडेंट सर चंडोक साहब के लिए बिग क्लैपिंग के साथ इनका स्वागत करें। ये हमारे लिए बहुत गर्व की बात है कि सर ने हमारी शॉर्ट कॉल पे हमें कंसेंट की और रिक्वेस्ट मेरी स्वीकार की। And the very second speaker, Kajal Chandra. So, I'm waiting. इसी सीरीज में मुखर्जी साहब भी हमारे अभी आ रहे हैं। आई एम रिक्वेस्ट टू क्यामुद्दीन साहब, प्लीज बिग क्लैपिंग join the seat. Audience and my सभी मोस्ट रिस्पेक्टफुली जो आज यहाँ सभी लोग प्रेजेंट हैं, ये हमारे लिए बहुत गर्व की बात है कि आप सभी लोग इसी तरीके से हम सब लोगों का एक हमें मोटिवेशन मिलती है। और हमारे जो स्पीकर्स आज के हैं ये बहुत हमारी रिक्वेस्ट पर और आप सब लोगों को मार्गदर्शन के लिए पधारे हैं। आपसे अनुरोध है और आशा करता हूँ इनको बहुत ध्यान से सुने और इनकी जो मार्गदर्शन है अपने आप में एक बहुत बड़ी बात है, बहुत बड़ी अचीवमेंट है। सो प्लीज सभी लोगों के लिए एक बार फिर क्लैपिंग के साथ हमारे सभी स्पीकर का धन्यवाद करें, स्वागत करें। इसी के साथ में हमारे बीच में हमारे सुधीर साहब भी विराजमान हैं, इनकी भी बहुत अधिक मेहनत है। इसी के साथ में इनका भी एक क्लैपिंग के साथ स्वागत करें। रिक्वेस्ट जी वर्मा जी, पिलर ऑफ दिस ग्रुप, I am request to proceed the further proceeding. I request to Varma ji.
आप लोग सबको स्वागत है। आज हम लोग 7वां लेक्चर सीरीज, 7th lecture series of the Delhi High Court Consultancy Lawyers Group is being organized here. We are delighted to have the distinguished speaker and one of our most honorable leader of the bar is none other than Amarjit Singh is also here, and along with me, Kajal and Chandra, the leader of the bar, is the daily leader, and the third speaker would be our Shoumendu Mukherji. He is one of the young lawyers and graduated from Calcutta National Law School, and for last 12-13 years he is into the profession. And the fourth speaker would be our Mr. Quyamuddin ji. He is having a good practice also in the civil side. Prior to that, I just wanted to tell everybody that in the civil side, Amarjit Singh Chandhioak ji is a pillar to all of us. Not only here in Delhi, but across the nation also we can say that. His knowledge, well, about to call him. I thought that, sir, may I accept our request or not, but he was very generous in this manner also. I am very happy also that sir is here with us. So without making any delay to today's program, because it's a very short span of time we are organizing within an hour, we are finishing the entire program. But prior to that, I will also tell you that with me, we have got a 5 persons kind of group. AKG is also one of our the executive person also in this organization. Then Sudhirji is here. Nandita Rao and Najib ji, they are in their legs in the courts. But they are coming. So without delaying, I would now request our first speaker, Mr. Quyamuddin ji, to start with the program, start with his lecture on regular past topics.
With your permission, sir.
Go ahead.
Good evening to all of you. And I am looking here again advocates who are very much interested to hear about this substantial question of law in RSA. So what is RSA? This full form is regular second appeal. And second appeal lies in High Court here in Delhi. And it comes under section 100 of CPC. But what does it cover? That RSA must cover that once a substantial question of law should be framed in that RSA. Factual matrix, whatever you write, you can draft in the second appeals. But substantial question of law is to be framed in that. So what is substantial question of law? There are two types of question of law. One is called substantial question of law, another is called question of law of general public importance. General public importance. And then first substantial question of law. What is that? How to frame that substantial question of law? When you frame a question of law, it must be related to your case. Then it is a substantial question of law. If it is not related to your case, but related to general public, it is a question of law of general public importance. So if you frame a question like this, which becomes more general, too general, not related to your case, not related to plaintiff, not related to defendants, not related to the evidence led by the plaintiff or the defendant, not related to the onus of proving discharge or not discharge, all these things which are related to case only, then it becomes substantial question of law. What happens when you draft a RSA but there is no question of law is mentioned at all? What happens then? What will happen? In 2002, in our High Court, one case was filed that was Satish Narayan Sood versus Kanchanwala Sood. RSA 61 of 2002. This is very important why I am citing this. इस RSA में कोई substantial question of law था ही नहीं. जज साहब ने कहा कि this RSA is devoid of the substantial question of law. वकील साहब ने एक स्टैंड लिया कि आप फ्रेम करिए, अगर हमने नहीं बनाया तो आप फ्रेम करिए. And then Honorable Court framed the question of law. How it was framed? Standard set by, in the case of Chunnilal. Sir Chunnilal Mehta case is in 1962. That is very important case. In that it has been decided in para 6 of that judgment. It was said that what is the substantial question of law? They said that means if a question of law which is related to your case, then it is substantial question of law. So in that case in RSA, the question was framed, which I said just now I said that Satish Narayan Sood versus Kanchanwala Sood, there was a case. In that a question of law was framed. And that is very important to see that question of law framed by the judge fulfill the whole parameters set by Sir Chunnilal Mehta. So I'll read how the question was framed. Now see, this perusal of the record shows that the appeal was admitted on 2/8/2002. Submitted substantial question of law has not yet been formulated because this RSA was not containing any substantial question of law. And the Vakil Sahab took a stand that court should frame. So the court framed. The following substantial question of law has arisen. It reads as follows. Whether after the death of Kamlesh Verma Sood, plaintiff number 1, on 1/10/1992, the suit having abated in 1193, could orders be passed on a pending application under Order 1 Rule 10 CPC of the Code of Civil Procedure on 27/9/1993, and if so, its effect. I will circulate this one to you, all of you. So, what is the requirement which has been fulfilled? See, the substantive question of law is like this: whether after the death of Kamlesh Parvasu, the name of the plaintiff is mentioned, that means it is related to your case. Court would have framed this question whether after death of the plaintiff also could have framed. And the factual matrix is also there. On 1/10/1992, and the suit was pending, and during the pendency prior to that one application 110 was pending there. And 1993, after the death of the plaintiff, the application was allowed. Appellant took a stand that since plaintiff has died and within the stipulated period of limitation, no application for implement of LRs came, so suit was abated and court was precluded from passing any order. But this judgment, this question was settled and it was decided that this suit was not abated because the application was pending there. And when the order was passed, subsequently, it was correlated from the date of filing the application. The judgment is also, it is reported judgment. So I will circulate this judgment also, you will go through it. This is a very good for the student and for the young lawyers to know how the substantial question was framed, giving the specific details of your case. That means whether the suit was abated, it is too general question. But when it will be substantial question of law, when it will be related to your case, the facts related to your case. If it is not related to your case, it does not become the substantial question of law. This is the test. Now, I'll say few of the sentences how we frame the question of law. While framing the question of law, we will keep in mind that means it should not be on the side of question of law for the general public importance. Suppose if you frame a question which is not even related to our case, but you frame a question of general nature, too general nature, then it will be not be a substantial question of law. It will be a question of law, but not substantial. It will not be subject matter of RSA. Then what will be? It may be the subject matter of SLP, but may not be the subject matter of RSA. RSA should be substantial question of law related to your case only, case only, case only. Now I'll say that the Chunilal Mehta case, how they said, that means when substantial question of law, what were the constituents of substantial question of law? One I said related to our case. Further they said like this: the proper test of determining whether a question of law raised in the case is substantial would, in our opinion, be whether it is of a general public importance or whether it is directly and substantially affect the rights of the parties. This is very important. The question should be framed in such a manner that it should have some effect on the rights of the parties in the lower court or in the first appellate case. If it is not related, then it is not substantial. So this I will circulate. With this, I'll say that there are certain things which we generally, while drafting a RSA, we keep in mind while framing a question of law. Like this, sometimes when we frame the question of law, we forget to analyze the case properly and we fail to ascertain that what the wrong has been done by the learned appellate court, first appellate court. Generally what happens, whatever the evidence is led, that evidence is not appreciated properly. Proper means legally. And sometimes irregularity is there, sometimes perversity is there. So you can frame question on those also. When a law is violated, it is called illegal. When a regulation or rule is violated, it is called irregular. When fact is analyzed in different way, it is perverse. So in this situation, you will have to analyze as a lawyer whether any law has been violated or not. If violated, then you can put a term that it is illegal because this law has been violated. If some rule has been violated, you put that this rule has been violated. Then if some perversity is there, you write perversity. What is perverse? Perversity is nothing but wrong assessment of facts. facts has not been correctly ascertained or fact has not been correctly analyzed, then perversity comes. So sometimes what we frame the questions, I have suggested few questions like this, whether the first appellate court was justified in interfering with the findings of the fact reported by the trial court without any perversity or illegality. This is a general question like this. But related to your case, here you can add also whether the first appellate court acted in violation of or court was justified interfering with the findings of fact recorded by the trial court on the basis of the evidence led by the plaintiff or on the basis of the evidence led by the defendant. You can add it like this. Further, I am suggesting whether the first appellate court has acted in violation of Order 41, Rule 33 CPC by not giving reason for the revising the trial court's finding. Secondly, whether registered agreement can be disregarded on mere oral evidence contrary to Section 91 and 92 of the Evidence Act. Why I am saying all these things? Because generally when we draft RSA, we give much more emphasis on fact. It should not be. Fact should be briefed as it has been analyzed in the trial court. Then you should come out with the law. Which law has been violated? Which regulation or rule has been violated? How the onus has not been discharged? How the onus has been discharged but court has not appreciated? So these are the things, based on those you can frame your question of law. And the question of law should be related with your case only. Then it will be a substantial question of law. I think I am very brief on this, and after this I will give my mic to some other speaker. Thank you.
Quyamuddin Sahab, in fact, has expressed in a way the regular second appeal, as everybody knows, and the new facts cannot be brought while you are in the regular second appeal. Two of the major judgments he has also discussed. So, from Quyamuddin ji, now will be going to our second speaker of this afternoon, Mr. Shoumendu Mukherji ji. He is also having a good practice. He is a senior central government counsel in our Delhi High Court. Besides, I have got a AOR. He is also a AOR in Supreme Court. So we will hear Shoumendu Mukherji.
Namaste. Thank you very much. It's an honor and privilege to be on the same stage as legal luminary as Mr. Chandra sir, sir, the entire team of the consultation. It's an excellent concept that has been started. We are all aware that Supreme Court has this concept of Friday lectures on law. I congratulate the team for starting this tradition in the Delhi High Court. Prasanta gave me a very limited aspect that I should focus on. And sir had asked me to focus on the types and nomenclatures of RSAs in the Delhi High Court. So while researching, we came across that Delhi High Court follows the standard nomenclature, which is RSA, as compared to first appeal, where we have various types of right to first appeal, which are RFAs, which is RFA commercial, RFA from say civil suit, criminal side. But when it comes to second appeal, which is RSA, there is only one type of nomenclature that is followed. Commercial Act, a lot of people do practice on the commercial side. Many of us would actually realize that there is no second appeal out of commercial, under the Commercial Codes Act. For commercial courts, once you have filed a particular commercial suit, directly the challenge goes up to the Supreme Court. So there are no RSAs available under the commercial courts. Now, to widen the research and to widen the applicability and the understanding of RSAs, we actually went a bit further to see that apart from Delhi High Court, what other courts who have this concept of RSAs, do they follow a different nomenclature of RSA? So we came across the fact that in Punjab Haryana High Court, there are two types of RSAs that are followed. One is RSA, which is regular second appeal, and that comes from orders from the lower courts. They follow nomenclature of RSA. And there is something called second appeal order. So when there is a RSA that is filed, second appeal that is filed, interim orders, say on orders on application for stay or some other application, they follow nomenclature of SAO, second appeal orders. But in the Delhi High Court, standard common nomenclature is followed of the second appeal. Even orders, interim orders under the second appeal, which are first an application because of some other issue that is raised by the parties, RSAs are followed. SAOs are only followed in the Punjab Haryana. So Quyamuddin sir, I may still so then moving on, Quyamuddin sir rightly said that while drafting, many of us have this habit of focusing on the facts and we don't really focus on the question of law that comes up. Yes, certainly, in the challenge, even when you draft the appeal, when you draft the appeal, that is the challenge for us, how to frame the question of law. Quyamuddin sir also explained that various types of question of law that do occur, question of law that may not go on to become what we call question of law. To give some examples, then I'll move on to different aspects which will not be probably covered by the other speakers, which are, I don't want to circumvent or come into the aspects that will be covered by the other speakers. That is why I'm limiting myself to a very, very limited point of the topic today. Now there are, right, some of us would be having Supreme Court practice as well. Apart from, say, after substantial question of law, the same, probably the principles and standards apply on statutory appeals when they are filed to the Supreme Court. There are some statutes, there are the NGT, the Electricity Act, the Child Regulatory Act. They have direct appeals to the Supreme Court. The Supreme Court also entertains matters where only if there are substantial question of laws involved. So just to give an example, if we talk about the NGT Act, I would just give some judgments as well, some citations as well, where question of laws has been dealt with. Now, NGT Act, section 22 of the NGT Act gives remedy to approach the Supreme Court under section 22, and there is also this provision or availability that apart from NGT's and say track, Electricity Act also under section 125 provides a statutory appeal, and it specifically provides that under any of those grounds that are provided under section 100, so section 100 of the CGC we are all discussing, so the same principle, same ground would be applicable when we are filing statutory appeals to the Supreme Court under the Electricity Act. Also under the Telecom Regulatory Authority of India Act, section 18 talks about statutory appeals. Now just to give certain examples of how the statutory appeals and substantial question of laws has been dealt with by the Supreme Court, and just to give a little flavor to the topic at hand. So the question was before the NGT was whether certain adjudicatory powers of the NGT can be probably passed on to certain ad hoc bodies that are there. So obviously the NGT has to adjudicate on certain matters, certain principles. Whether or not those powers can be passed on to say an administrative expert committee. So that was a question of law that was framed in that particular appeal. And to say that it was finally held that such powers cannot be passed on, powers that are adjudicatory powers that are held by the tribunal have to be adjudicated by the tribunal itself. It cannot be passed on. So as we observe here, factual aspects are very limited. When we are framing question of laws, factually and legally we have to differentiate and solely focus on principally legal issues that are there to frame question of law. Then if we go on to the Electricity Act that was considered, there is also a case which considered question of law, and there also the tariff issue was concerned, and while determining tariff, while adjudicating issues and disputes on fixing of tariff, so that was another question of that was framed by the Supreme Court, and it was pertaining to the DERC's powers to actually fix and control tariffs. So that was another example of fixing question of law. So on the overall, what I wanted to submit and probably take this discussion further was that question of law not just is restricted to Delhi High Court, we do have other high courts also. NPAs is another angle, but we should not get confused with letters patent appeal, because letters patent appeal goes before a division bench, whereas second appeals, regular second appeals goes before single benches in the Delhi High Court. So LPAs, there are certain confusions at times created whether LPAs can also be considered and be kept at the same level or same plinth as second appeal. That is not so. When we are challenging, say, lower court orders, we come, first appeals are there, then after first appeal, a single bench will only hear a second appeal in the Delhi High Court. LPAs, for another reason or for a different matter, there will be division benches that are constituted. And when we are going for statutory appeals to the Supreme Court, that may either be a single bench, because certain times Supreme Court rosters also change, because they also have certain single judges now, they hear bail matters. So before Supreme Court also there are division benches that hear. So on and on, just to summarize what I have tried, and as you also pointed out, there are times when lawyers, when they come in for draft, when they come in for release, they don't have questions. So at times the courts also come in and they determine what is the question of law. Commercial sum up, we don't have second appeals at all. With this, Prasanta, hope I am able to throw some light on issues that are a little different, and which may not be covered in the usual discussion and discourse further. Thank you.
You have tried to open yourself up, and sometimes what happens when we are amongst the hardcore civil litigant lawyers, then obviously our knowledge is required to be of such level also sometimes. We may have started our practice in various directions, but Shoumendu, in fact yesterday, myself also were discussing on this issue, and I was under various other impressions also. In so far as regular second appeal is concerned, I have also handled number of cases wherein we were into the principle of res judicata, and that was ultimately moved to the district court after certain orders in their own departmental proceedings. They had availed those departmental proceedings and they have also trial in that court. Then they come to the district court. So when we challenge that, there also the question of law was framed and it was properly been dealt with. I am saying that why I am saying there are various avenues, various issues on which the regular second appeal and the subsequent by the court. In a position to Chandra, she is also good, very good. I have seen her practice and her the group of people. I feel quite envy also how a lady lawyer can also practice in such a magnanimity, and she is always busy. We will hear Kajal.
We all are referring much on the facts rather than on legal. Whereas the second appeal only talks about that when you're drafting, when you're filing, the court will only see that it is mandatory for you to go into the substantial question of law. Unless it has not been referred, it is not your second appeal is not going to be maintainable, and the court cannot, and this has to be seen at the time of the admission of that appeal when it's listed. The Honorable Court has to formulate that substantial question of law. Then only the court will proceed further, and the respondent is being asked to answer to those questions only on the basis of those substantial question of law. We are not going to touch about the facts, anything, because that the first appellate court has already dealt with it. We are now only going to be on the section 100, 101, clause 1, 100 clause 2, 100 clause 3, all this is talking about, even where the cases, in those cases where it is an ex parte decree. Yes, it is being challenged. You can do it, but you have to see whether that second appeal is maintainable or not, because there can be a mixed question of fact and law at the time when you are filing your second appeal. Court will only look into it and go through the trial court if it is required. Otherwise, the court is not going to do it. It cannot become your third trial court. It has to only see whether the law which has been dealt by the lower court, the first appellate court, has been dealt in a proper manner or not. and only when there is courts where it is very difficult to frame that substantial question of law, as Mr. Kamruddin has also said, that question of law and a substantial question of law, what is the difference? The only difference we can find is that the law applicable is correctly applied to the established acts which you had dealt with before the first appellate court. So that is very, very important. Those facts court had not dealt with that number of court cases. I think so. My Mr. Kamru also valid. The latest being of Dr. R.N. Singh versus Union of India. Justice Anup Jairam has said dealt with it and has dealt with it in his judgment in para 12. He has, in a very detailed manner, has said, I'm carrying the citation. It's been decided on 15th May of 2025 that various courts have said so. That the requirement of regular substantial portion of law has to be appealed. So meaning that what we used to do it in first appellate court is only grounds of appeal. Here only the questions of in fact earlier when I joined my profession, there used to be only 2-page or 3-page of appeal RSA. Not even a fax was read. So the same thing has to be seen, and the Honorable Court has to formulate it. Then only your RSA can be maintainable. Otherwise, it is not maintainable. It will be struck off, and the court will say, these points have already been dealt by the first appellate court. And if I just go through it, one of the in the same judgment, the Honorable Court has said the requirement most fundamental under this section is the presence and framing of a substantial question of law. In other words, the existence of such question is sine qua non for existence of this jurisdiction. It says that and this amendment came only after post 1976 amendment which came in CPC. Prior to that, we were, facts and question of law was being taken into it. But post 1976, the court didn't want to keep every time one order has been passed, it will be again appealable. So at some stage, the litigation has to stop. So post 1970, only then the substantial question of law can be taken into consideration. And I think so. My senior would like to add on anything on that, because both my speakers have already dealt with.
Kajal has also dealt very precisely, and it is on the issue that you cannot add some more facts in your while framing a question of law in your petition in a regular second hearing. Actually, when we look into section 100, thereafter also she was saying that we also have a look into 101. What are the petitions which we can, or how we, under what circumstances, we will be filing our RSA, whether it will be maintainable or not. If it is against any high court judge, single bench order, whether it is the RSA is maintainable or not, or those aspects are also there. So without taking much of your time again, I am just to say that, because I am conveying, having the convener part, I am only doing it. So I would request our today's attraction is the best speaker. We can say that he is the leader of our Honorable Amarjit Singh Chandhioak.
We must start with thanking you all to be here. I learn every day, and you all have been teaching me. All this my friends have said, for my youngsters, I can tell you all that is what is right. But yes, it's a question that emerges every day. My three friends have already given me various aspects of it. I actually want to take you to the statute first. Prior to its amendment, as Father has said, it was not necessary for us, as lawyers, or the litigants to state in their second appeal if a question of law arises. But today a condition precedent has been made that you must, in your facts of your case, state what your opinion as a lawyer, are substantial questions of law that arise in that particular case requires consideration again. First question. The precondition is that. So I do not know, because I hardly use that, so that you may be able to tell me maybe AI has already developed this. Even RSS are not coming from AI. I have no idea what it is. But the one wonders, actually speaking, how can AI be able to appreciate your mind to see what substantial question of law is? But maybe technology is going very fast, so we don't know yet what's happening. We're able to do it. So my first request to you all is that you must master your facts. If you don't master your facts, you will not be able to call out this examination. Two, find out the errors in the first judgment, which are giving rise to your mind thinking to see what questions. So the word used in section 100 is notwithstanding what you state in your appeal, you have to satisfy the court with question of law. Unless I know my facts, unless I know what errors have been committed in RFA or the trial judge, I really can't do anything. So you must, in every litigation to my mind, a lawyer must first make an endeavor to understand, appreciate, and grasp the facts of the case. So normally we omit many things when they are drafted, especially when there's a lot of litigation, then we tend to, one suit would have said something else, another suit will say something else, the third suit will say something else. That has to be first avoided. When you frame your question of law, then you are now before the court. It is possible for you to, during the hearing of the court, that from your facts only, from the trial judges of the first appeal, the question that you have formulated may not be correct. You may assist the court to say, yes, I have written a particular question of fact or law, but during the hearing I find another question of law. That does not bar the court to frame a question of law. So the obligation first is on the litigant, that is us, who represent them, to frame questions of law. Second stage is satisfaction. Third stage is court's obligation at the time of admission to frame those questions. So the question is, does that put a full stop? The answer is no. Even when the final hearing of that appeal is there, suppose the law changes. There is a change in law. Change in law can be two ways. The Supreme Court can change it. The statute can change it. The legislation may change it. Something else may happen. I'm just giving you an example. This has nothing to do with your case today. When we brought Hindu Succession Act amendment in section 5 and 5, the Supreme Court first time said if the father is dead, the girl is gone. That girl got to do the father's death. I as a girl got a right by my birth. So if I was alive on the date of the death of my father, then I got a right to pass on the property. The Supreme Court said no. Father goes, daughter also goes. It got rectified again. So the father has nothing to do with it. Now to take a case which is in the first appeal, the Supreme Court first judgment decided your appeal to be dismissed. He says, sorry, the father died. But by the time you raise this question again in the second appeal, the law is changed. You'll be entitled to make that, frame that question of law, notwithstanding that you had not framed it. In the last subsection of section 100, the court gets the power. There is no bar, nothing can bar the court. No estoppel works against the court. We are the only two kinds of communities, the lawyers and the judges. No estoppel works against us, no res judicata works against us. Parties may work, not against us. You may today argue one thing, you may argue the other, next day get another brief, argue on the other side. So don't feel, oh God, yesterday I argued on the other side and today I am going before the same judge, arguing to the contrary. Nothing works. There is no estoppel against you. And there is no estoppel against the judge. In fact, we have a very famous decision from House of Lords where the lawyer was arguing and he argued totally contrary to what he had argued before the same judge when he was a judge of the Court of Appeal. The judge put it to him that you are the person responsible when I delivered that judgment in the Court of Appeal. He says, Lord, nothing applies to me. I learn every day. Therefore, please don't get bogged down by the fact that yes, one day you've done this and then you can do everything. Third most important situation in my view is that when you formulate a question of law, read your statute. Statute comes which you are actually making an argument. You will find various statutes. Take example, RERA. RERA by its section incorporates section 100 of CPC. There is no section 100 there. But by section it incorporates the entire section 100 into it. Same is the position to a learned friend said to other enactments. There are other enactments where you will find no mention of 100, yet it says appeal will lie only if there is substantial question. The legislature takes three things. CPC as one, it provides what is 100. Then in other statutes, it incorporates itself, picks up 100 from CPC and incorporates in the statute. And says you will only file an appeal if the conditions of section 100 of CPC are met. There is a third category of statutes which will not refer to 100 but will use only the expression appeal if substantial question of law arises. All these three are brothers and sisters coming from the same position. So don't get worried about it. There's nothing else. And it is possible. You as lawyers will have to examine it. That when you enter the courtroom and the final hearing of the case, as I said, law might have changed. The law might have gone against you. So you should now develop an art how will you distinguish this position into a substantial question of law. I just give you an example. If you were to argue, supposing you read that judgment and you're appearing for the other side and say, yes, the father died, girl has no right. But by the time the RSA comes for hearing, law has changed. It doesn't bar you. But you will have to now stand up to say, notwithstanding the change in law, this girl can't get it. Because maybe her father had made relinquished consent. So therefore, notwithstanding that the stress is not on your facts, yes, I agree. But unless I have facts here, I can't do it. It's very, very important. Especially for my youngsters who are getting used to AIs, please don't get it. Take them as your tools. Yes, I agree. Suppose you get a brief of 5,000 pages, use AI to select what are the important pages that you must read. And when you are going to draft your appeal, after you have made your first draft, read your brief again. You will see yourself will come out with more questions of you than ever thought. I'm grateful to all these my friends who are doing this opportunity to speak. Therefore, we have to understand what are we doing? What's our duty? There is one thing to say I have a duty towards my client. That's no dispute. You have it. But there is something duty to your inner self. We as lawyers are something to do with ourselves. First get satisfied within yourself before you satisfy your client. If you are satisfied with a pure question of law, I'm sure you will be able to do it. If I am not satisfied, I'm sure I will not be able to do it. Let me give you a clear-cut example. I can think with one or two of us have appeared. We had a great judge here called Mr. T.P.S. Chandra. I think he probably was from BBC at one point of time. His accent was English. So his suit is filed. If you are knowing about Delhi, Delhi has a project very Delhi. At that time, Bhattis used to be right outside. And this person used to stay on the first floor. So he filed a suit for injunction, saying that this smoke is violating my rights. He was dismissed. He filed the first RF. He was dismissed. Now comes the second. So he goes before one judge, he says, where is your plaint? The plaint is filed. Roster changes. He goes before another judge. He says, where is it? Entire trial court record you should have filed. Again, roster changes and come before this judge. So everybody is perplexed that what question of law will you raise in this case? But he is a question of fact. You are staying on the first floor is a fact. Now see what is the question. Does Article 21 give you a right to stay and be healthy, or can be interfered by unlimited neighbors by putting a material? And the intelligent, of course, the honorable judge was. He did not look at any one of us. He framed 4 issues out and granted the injunction. Suits are dismissed, appeal is dismissed, but in RSA injunction is granted. Matter got settled in 1 month. Business was stopped. So look at what you are saying. The point that I am making is only think on your feet. It is possible while you are even arguing at overlook it. You never know. And I'm sure those of my colleagues are there with enough experience, those youngsters will get it. Take the same facts before Judge A. You'll find this business. Take the same facts before Judge B. You'll get a notice and nothing. Same situation. Because your mind has to work as to what goes well with this honorable court. In some court, you just raise your saying this is a question of law, you'll probably get a notice. In some cases, you have to struggle. I still remember this Ayatollah came and spoke to Supreme Court. He said, who told you we can't be wrong? But we are final. But that finality is also now gone. Because we file review. If review is also dismissed, they file an accumulative petition, and arbitration award is set aside. Don't go by what Supreme Court does, please. Go by what this does. Be innovative. Inspire yourself. Ignite yourself with that brief that comes in your hand. And why I'm saying so is this, all lawyers have no religion. Let me tell you. I'm not a Sadar. He's not a Hindu. Because our place of worship is our file. If I respect my file, if I do justice to that file, actually speaking, I worship. And that's why it's necessary for you to go into each bit of that file. So it may look very old to say all this. But yes, but I still feel old is still good.
Always.
That is a base for learning. And also requesting you, since my friends have brought these topics, which are very high magnitude, we must all learn. And I must tell you, even at this age, I learn every day. My briefing counsel teaches me. My intern teaches me. Because the child is more innovative than I can be. His or her brain works faster. She has more tools. We used to have this one big, couldn't digest. Then we used to look at that time my turban used to have an oil paint. I used to take it out, tear a table, paper and put that oil. That's gone, posted has come. So my suggestion to you is, please whenever you finish your day or your work, go to a court to see who is hearing and what is he hearing. A bank guarantee matter was dismissed by a very eminent judge. You must have heard his name, sitting on the original side. At that time, Arbitration Act was 1940. So he was one case, I was another case. I'm just taking our names. So it dismissed both. So I went first to the Supreme Court, because against that section 41, schedule 2, there was no appeal provided here. You got a notice and a stay. When I went to Supreme Court, dismissed it. I told him, Lord, I have filed an affidavit. Now see how you think on your feet. I am saying the Honorable Judge has actually copied that very judgment here, except for 2 paragraphs. And there is Chandra to be Chief Justice then. He said, we'll reassemble, get that file for us. And we were able to establish it. So all these instances I am only quoting for you to don't get discouraged by the fact that a particular judgment is against you. Develop your habit to distinguish it. When you take that, what you put it in your brief, how will you make a new question out of that? That can also be a substantial question. And you said rightly so that you are not talking about PILs. You are raising questions of really public importance. That's different. Delhi should have more sanitation. It's public interest. It's PIL. But if you were to say something totally different, that my house gets flooded with just little rain of 1 mm or something, personal right now. So that's also a substantial question of law when you raise before the court the obligation of the state or municipal corporation to provide sanitation on that road where I happen to stay. Question is the same. How you formulated the question? So this discouragement of reading a judgment, why I'm saying, because I see today, why I'm emphasizing on all this, I must tell you that. Because today you tell a child, I'm looking at law, he or she goes to the computer, looks at one line and says, that's such that matter. Judgment is in the context of that case. Judgment is not there in abstract. In the facts of that case, therefore, again I am coming back to the emphasis on facts are important. Yeah, it may not be stated as my friend said, yes, I agree. You may have to summarize it. Because questions of law that you will put in your RSA will also come from those facts only. And it is possible to formulate a question which may not be in the fact only. Suppose the learned first judge just dismiss the first appeal without going into the question. The question of law would be, what was the obligation of the learned second judge? He dismissed the appeal. Because the RFA, we have both questions of fact and law are applicable to you. And today the Supreme Court has laid down consistently. I'm conscious, I'll finish it today.
No, sir.
That if an RFA is dismissed without going and examining the evidence once again, it is his obligation as a judge on the first appeal court to examine your suit record, come to his own conclusion and then say, trial judge is right also on this or wrong. Not otherwise. You can't simply say, I've gone through the records, I find everything to dismiss. No. Then now is the question of law. If nothing arises from your facts, it arises in the circumstances. Therefore, we are all soldiers. And let me end with you on a lighter note. I was speaking at question was asked by an intelligent person like my next friend sitting to me. 60 years have passed, you still call your judges as my lord. Copying the British. I don't know from where it came to my mind. I don't know myself. Don't ask me. So I have to now reply. So I said, no, this is wrong. Actually, the Britishers copied us. Because in my country, we all feel, irrespective of caste, color, creed, religion, that only one place you get justice, that is God. And I remind him when I say, my Lord, that look, God has bestowed on you this honor, do justice in this case. So please rise to the occasion. You people are youngsters, much faster, much better equipped than we oldies are. Don't take it that I'm old, okay? Otherwise, in the next election, you won't let me do. And this is a great effort, I must say, because we can interact here, we can talk to each other. We don't get this opportunity. We don't get this companionship that we must have. We've lost it. Our mobile phones are coming in between us. A wife today talks to her husband also by WhatsApp. Even if they're in the same house. The dinner is late. You youngsters will especially see, they go on the dining table, they see your dal and roti, they say, no, tomato, they say, nothing wrong about it. But the fact that I am saying that companionship is free, I must relate myself to my friend. I must be able to relate to you. And please don't hesitate, at least speaking for myself, if you feel there is a difficulty that you're facing. Anyway, in the case, outside the case, in the bar, outside the bar, I'm not telling that I'm on. Of India. And secondly, he says it's the only high court I saw where lady lawyers were not only asking questions. They were actually again a compliment to this institution to which you and I belong. Keep it up. You are our future. Our future is bright. Don't worry about anything that there are 34,000 members in the Riyadh Parliament. What? But now that you have mentioned that, madam, I am appealing to you today through all my youngsters here, that a bar must keep track of this to see how will it go. In terms of infrastructure, in terms of everything. And this effort that these 5 friends or 4 friends of mine are doing is laudable. Increase it. How many times we get an opportunity to talk like this? No more. We meet at best, those who know me will probably wish me every day, that's all. Nothing else. But we need to talk. I'm not saying don't enjoy yourself, please don't listen. Enjoy. But while enjoying also you can say, the other day I saw Kajal saying something else in the book. Was she right? Put a question to yourself. you get the answer kind of questions. Was the judge not observing? Was he right? Because you are, while you are enjoying, the purpose of my telling you is, you must have a smile when you are doing your work. If you smile and do your work, you will see your potential be twice what you get at. If I am always saying, yaar, ye kya de diya mujhe senior ne? Na iska sena, na iska pair. Take it as a challenge. Meet that challenge. And I can assure you, in the institution to which you belong, go anywhere, Delhi today has maximum cases of individuals. No other court has. No other court. Even district courts don't match it. You get 87% of IPR cases in Delhi, throughout the country. You can your potential. 67% of what you call tender matters in Delhi. See the opportunity that you're getting. And the only high court which has two centers with it, mediation on one end and arbitration on the other. So alternative dispute is also they provide here. In fact, we got a chief justice became chief justice of India, P.K. Mishra. When he came with this mind that I must close this arbitration center. Should we do it? We should both have arbitration center. Mediation he could not do because 89 provided. CPC had been amended by that time. So he could not say anything about the mediation. But he said, why should there be an arbitration center here? They just tried their best. And it was put on my head now that I as the president should go and convince him. So he was very fond of food. So he had invited me 2-3 times to say, come home, let's have tea together. So I said, no, I can come for tea. Which day? Without mentioning it. So he fed me. I don't want to tell you what happened after that, but he fed me properly. But I didn't raise that issue. Again, I did the same thing. But at that time told him, Lord, I would like this P.K. Mishra, going to Chief Justice of India, to write his tenure in platinum and gold. Why should you be destructive? He said, I'm not destructive. I said, then you're not going to talk. Send him. He said, yes, I'll do it. So think about this. What my purpose of giving you these examples is that sometimes you have to substitute yourself from the rigors of pathway of. We are not horses with having those flaps. We are lawyers. Think of something new. Inspire yourself first. You will be inspired by them. You should be inspired by yourself. And once you inspire yourself, sky is your limit. Have a good evening, a great weekend. Thank you so much.
Thank you so much, sir. Just want to introduce you to sir. Sir is also a former ASG. And the whole picture of what you are seeing Delhi High Court today is because of sir. Yes. All these new buildings are because of sir. The Samadhan which has come, it was only because of sir, the mediation center has come and has been retained, and only the lawyers are being as a mediator. This is the only court where you can. So the whole court is everything. Everything. Whatever people are taking in different tenures, the benefit is not. I can't say anything. I had seen Delhi High Court what it was and what it was later than another tenure of sir.
No, the only purpose I must tell you, Kajal, the purpose is that who can be a true leader? To my mind, a leader who understands not his own pain, of my left hand.
We will be concluding today's program. Very excellent lecture from our prominent leader of the bar and is also a dynamic lawyer of the entire country, I can say that, in the civil side. Whenever I have seen him on any civil issue, civil matters, he has got a different peer altogether thinking and expressing or conveying to the courts. So today a In fact, we have concluded the 7th series, and hereafter also, as yesterday the Lok Sabha was also saying that he is very happy and will be also like to invite him as and when any other topic comes, which he will be also, we will be also feeling quite comfortable. Today the arbitration matter across the globe. Yesterday also we were discussing upon amongst the youngsters and the new words, new phrases which is coming up. Yesterday sir was also to have in our programs, younger generation particularly, we are also organizing. There has to be a harmonious relationship with the seniors, with that of the youngsters of the bar. Delhi High Court Bar Association is excellent, and I have gone to many parts of our country, even though I am not from Delhi itself, but I started my practice also way back in 93. And whatever I have learned or whatever I have gained, I understand is that Delhi is totally different. And as sir was saying, it is in the original side, civil side, IPR matters, many things. You cannot have all those aspects in different parts, other parts of the country, even though we have the other 3 metropolitan cities, but Delhi is excellent. So with this, I will be requesting Sudhir ji to give a vote of thanks. Let Nadim ji and Nandita, we all 5 of have started this. Other friends of our consultancy room are giving us a good help also in this matter.
Don't let us enter consultancy bureau.
Also, honorable audience, time to say shukriya और धन्यवाद. But before that, I must say, आप लोग समझ गए होंगे why Singh is king. And whenever you see this, just say Amarjit Singh Chandra. शुक्रिया कहना एक बहुत जरूरी बात होती है. किसी भी वोट ऑफ थैंक्स की एक बहुत जरूरी दीवार नहीं, ये बुनियाद है. इस हक का रिस्पेक्ट आप सबके लिए, आप सबके लिए. क्योंकि शुक्रिया कहना एक बात में मैं कह सकता हूँ, शुक्रिया आपके आने से आज रौनक और बहार आई, वरना ये महफिल और जज्बात अधूरे थे. मगर सच बात यह है कि आप लोगों की नॉलेज ने और आप लोगों की बातों ने, आप लोगों के वक्ता ने आज सभी ऑडियंस को बहुत ज़्यादा खुश किया. Definitely when I start by Honorable Shri Quyamuddin Sahab, he has immediately stated what is the subjective matter for an RSA and which could be either be inhibited with an SLP, but what is important is the understanding of your case. Shoumendu ji, he has stated a very good anthology in the kind of appeals or the RSA that could be there in various different fora. So we must understand where we are going and what we are doing. My very learned friend, Honorable Senior Member Executive of our bar, Kajal Chandra ji, ma'am has stated very instantly the first step which I think you must have understand. Section 100 and Order 42. We must understand what is Section 100 and Order 42 before we initiate with the RSA. And afterward, our star speaker. Whatever the sir has stated. Sir, Amritsar de to sare hi Sardar star. मैं भी अमृतसर का हूँ सर.
I'm not from Amritsar, I'm from Delhi.
But whatever Honorable Sir has said is rise, innovate, and integrate all those ideas. So here I say thank you very much, audience. Thank you very much, honorable speakers, for your kind and august presence. Thank you very much, you enlightened us. Now I request everybody to have tea and refreshment with us. Thank you very much for joining us. Thank you.
Topic for our next.
Next topic is on CRLNC, criminal miscellaneous petition. It will be on 22nd. 22nd August, because 15th is a holiday, so 22nd August we are having.
उनको बोलो ना लेकर आएंगे वो चाय वगैरह. किधर लाना है? हाँ इधर लेकर आना सीनियर्स के लिए.